Good day. My name is Ryan King, one of the senior legal advisors from SEESA in Pretoria.
Good morning. My name is Johan Plessis. I'm one of the legal advisors at SEESA Pretoria.
Today's topic is an interesting one. It deals with unions attempting to exercise organizational rights within a particular industry. And often what happens is the industry doesn't associate with the constitution of that particular union. And this one went to a few of our courts, Johan.
Yeah, Ryan, this one went through the Labour Court, Labour Appeal Court, and even to the Constitutional Court, where also we're dealing with the right of freedom of association, the right of freedom to join a trade union was subject to its constitution, and also the Bill of Rights, where the limitation of rights is applicable. And the courts found in this instance that the limitation of rights with regards to the LRA, the Labour Relations Act, is valid.
So just to give everybody a bit of background, the National Union of Metal Workers of South Africa were attempting to exercise organizational rights in a company that fell within the packaging and paper industry effectively. And we've long known that NUMSA's ancillary or direct application has always been in the metal industry. And what the company argued in this matter was that the constitution of NUMSA made no provision for them to exercise any rights in an industry that fell within the packaging or paper ambit. So, Johan, take us just through what the courts considered.
Yeah, what the courts considered there with regards to the constitutionality of the mine workers' constitution is that they stipulated that if the employees join the union and it falls outside the scope of application of the employers, effectively an employee cannot join the union, as it will be unlawful, as the union will then act out of its own scope of application. So in effect, the court found that the unions are bound by the constitution and that they cannot act out of the scope of application. So they limited the scope of application in their constitution, which in a sense is a victory for employers in this day and age.
Having said that, though, it's only a short victory in terms of what are the unions likely to do at this stage?
Yeah, the Constitutional Court left it open. They indicated that the unions can amend their constitution during their national meetings, which obviously must take place once a year or once every 2 years. So it's a short-lived victory for employers. We presume that this will be amended within the next year or so, and that they will open the application or the scope of application to include various employers that fell outside the scope of application.
So we're looking at most of the unions now upon their national congress or conferences to now widen that scope as wide as possible. I mean, a union effectively is a business, and they are also in competition with one another. And it makes no sense that they're going to limit their own scopes to limit their own membership. So we're going to probably have a plethora of widening across all unions that have now picked up on this aspect.
Yeah, most definitely. My advice will be to employers will be to utilize this time frame that they have to work with the unions and to get unions out to ease collective bargaining within the workplace. Employers should not be afraid to engage with unions and stating, listen, you do not fall within the scope of our application, because employers will have the case law to back them up, and unions will be powerless in this instance.
So there we go. All employers should go and look at the constitution of the union that they have in the workplace and study the scope with a fine-tooth comb to make sure it's applicable. Good. It was an exciting case, this one. It went on for quite some time. It went through all the courts, as Johan indicated. And it was an interesting one because we've long fostered this argument on behalf of our clients to say that unions don't have application in particular workplaces. And then finally, now there's an answer to it. Good. Yeah. Johan, thank you for this chat.
Thanks, Ryan. Appreciate it. Keep well.